thank you, sir. But I'm as jurists here deliberating. I'm going a level higher. What about the what is the relief we can offer to the casual migrant labor who goes and dies? What is the compensation? How do we seek a redressal of the grievance of the legal haste of the deceased people? How do we get the compensation? The law is not meant for those who can afford insurance. How are we going to provide? What is the avenue open?
Nomination and other facilities are already there.
Those are the only
you get it after.
We know they're very slack. So how do we try to get the present act amended?
You can file cases in India because you got insurance from the Indian company, not over there.
That's okay, sir. That's related to insurance.
Yeah,
We're speaking of uninsured students
and
others. We're speaking of uninsured students and others. Okay. Thank you.
Okay.
Thank you.
Good afternoon, everyone. I feel indebted to the International Council of Jurists for giving me an opportunity to speak at this wonderful forum. And as it is, since the thematic emphasis is on the agenda of speedy justice, I would like to present an overview as to why we need speedy justice and its importance on national as well as on international basis. Mounting of various of cases in courts, particularly in the high courts and the district courts, has been a cause of great concern for litigants as well as for the state. It is a fundamental right of every citizen to get a speedy justice and speedy trial for that matter, which also is a fundamental requirement for good judicial administration. In this report, I'll propose some of the observations which have been made by different judges as well as different judicators and different jurists at different points of time. In the courts, areas are mounting by leaps and bounds, and there is no respite in sight. This is particularly because of the cases in which much more than the disposal at all the levels of judicial administration. The fundamental requirement of good judicial administration is speedy justice. Quite often, frivolous, vexatious, and luxurious litigation also come up to add to the mounting of areas. Such type of litigation has to be controlled at the moment they initiate. Efforts should be made to decide cases, particularly mysterious matters, excluding the matters which require the evidence of witness, and at the party's admission stage after affording opportunity to the concerned parties. In middle of my speech, I would like all of you to participate just in case you feel like you're all welcome to include me in between. In India, there are almost 1,500 jails which are accommodating 3.5 lakh inmates, more than their actual capacity to accommodate almost 2.5 lakh prisoners. Approximately 70% of the jail population is made up of under trials, which mean the numbers which could be pegged at 2.45 lakhs out of these, according to the Honorable Chief Justice of India, 70% or 1.7 lakhs were booked for petty offences. So that's for us to observe that merely 2.5 lakh is the number which can be accommodated in the jails in India, and almost double the amount of people are actually fitted inside those prisons for petty offences which can be booked over those prisoners for fines and different fora. Our constitution provides for an independent and efficient justice delivery system. Delaying disposal of cases not only creates delusionment amongst the litigants, but also undermines the capability of the system to impart justice in an efficient and effective manner. On account of such deficiencies in the system, huge areas of cases have piled up in the courts at all levels, and ways and means are required to be found out urgently to bring them to a manageable limit so as to sustain the faith of common man. Judicial institutions in most of the developing countries in the world are currently confronted with serious crisis, mainly on account of delay in the resolution of the disputes, and we are no exception. Honestly, India is one of the countries which has the maximum number of litigations filed within a single week. A look at the statistics of institution and disposal in 1999 and 2006 in the High Courts would show that the total institution has gone up from 11,22,430 cases to 15,89,979, and disposal from 9,80,474 has obviously increased to 14,50,000 to 602. And these figures of institutions and disposal go to show that while the disposal has increased to a considerable extent, the overall situation continues to just increase and underpile all the number of litigations which are brought before the courts. And because of this rapid decision, though the pendency of cases always highlighted, what is never spoken of are the figures of annual filings and disposal. The increase in the institution is partly because of the increase in number of cases under Section 138 of the Negotiable Instruments Act and Section 498 of the Indian Penal Code and the enactment of new legislations in the recent past like Protection of Women Against Domestic Violence Act 2005, the Right to Information Act, etc. Besides inaction of the part of union government, the governments of various states and the central government as well, their instrumentalities in observing rules apart from maladministration. All governments and their instrumentalities should ensure that genuine cases are resolved at pre-litigation stage at their level so that the poor and helpless citizens may not be compelled to unnecessarily knock the door of the courts, and in this manner feasible number of cases by or against government and their instrumentalities can be reduced. Only those cases which may be taken by the courts where it is not possible to resolve a dispute because of legal efficacy should be brought before the litigation procedure. And also the tendency amongst the ministerial staff of all three limbs of the state, that is the legislature, executive and the judiciary, to harass the citizens of extraneous reasons is galloping fast, which can be minimized. If not eradicated completely by strong, independent and tactful administrators at all levels. It's time for the judiciary as well as for the people who litigate to think twice, at least 100 times before litigating a matter before the courts and the district courts, whichever is the particular fora, just for them to decide that it's for them to realize that how much time does litigation take to get through with. There is one more area which needs immediate attention to the executive about which it has been reminded in the past as well as that is vacancy of judges both in the high courts and courts subordinate thereto. Increase in strength of judges in various courts, keeping in mind the pendency of cases as well as the trend of institution of fresh cases and not the rate of disposal, providing adequate infrastructure to the existing judges by renovating the old dilapidated court buildings and making more space available to the courts. The Law Commission, in its 120th report, submitted on 31st July 1987, recommended optimum figure of 107 judges per million by 2000. The ratio achieved by USA in the year 1981. It also recommended a ratio of 50 judges per million of population within a period of 5 years, which was endorsed by the Standing Committee of Parliament, headed by Sri Pranab Mukherjee, in its 85th report submitted in February 2002. The Supreme Court has also directed increase in judges' strength of 250 per million in a phased manner, but despite all this, the strength of judges has not been increased. That is why also the judiciary is facing difficulties in tackling the problems of mounting elections. There may be some resistance to it in the beginning, but soon people would realize that once the litigation starts in any matter, be it in any court, be it the district court or the high court, it takes ages to get over, be it a frivolous litigation or of any consequence. It's time for the bench and the bar to sit together, deliberate on this issue and come to an understanding so that the length of an oral argument is restricted to save the public's time. I would now advent to some of the positive measures that have been taken in the past which have already started showing results and are significantly contributing in the increasing disposal in subordinate as well as the high courts, and those which are still required to be taken for dispensation of speedy and affordable justice. The measures that have already been taken are setting up of fast-track courts, the Lok Adalats, the mobile courts, the ADR system, insertion of Chapter 21A of the Code of Criminal Procedure about plea bargaining and setting up of e-committees, etc. In order to achieve the objective enshrined in Article 39A of the Constitution, the Legal Services Authority Act 1987 was enacted to provide free and competent legal services to the people who are not in a financial condition to fund their litigation. And moreover, to achieve that objective, Lok Adalats are being held at various places in the country and a large number of cases are being disposed of with lesser cost so that speedy and affordable justice could be made available to the litigants at their doorsteps. The philosophy of alternate dispute resolution system has been well stated by Abraham Lincoln way back, which was discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the normal winner is often a loser in fees, expenses, cost, and time. Litigation to the courts and tribunals established by the state is one way of resolving the dispute, which is an adversarial method of dispute resolution, which leads to a win-lose situation. Whereas in alternative dispute resolution, what is tried to be achieved is win-win situation for both the parties. There is nobody who's a loser, and both parties feel satisfied at the end of the day. The ADR mechanism include arbitration, negotiation, mediation, and conciliation, with a view to bring alternative systems into a mainstream. The challenge that we are facing today is bringing about awareness among the people about the utility of ADRs and simultaneously developing personnel who will be able to use the ADR methods without any difficulty. Also, with the insertion of new chapter in the Code of Criminal Procedure by the Amendment Act of 2006, the concept of plea bargaining became a reality and part of our criminal jurisprudence. The practice of plea bargaining is prevalent in Western countries, particularly the United States, the United Kingdom, and Australia. In the United States, plea bargaining has gained very high popularity, whereas it is applied only in a restricted sense in the other two countries, that is, the United Kingdom and Australia. Plea bargaining benefits both the state and the offender, while the state saves time, money, and effort in prosecuting the suspects. The latter gets a lenient punishment by pleading guilty. One of the merits of this system is that it helps the court to manage its load of work, and hence it would result in reduction of backlog of cases. If more and more accused came forward and bargained the plea, the reform could reduce the enormous backlog of cases in our courts. Plea bargaining apart, if the list of compoundable offences is widened and more offences are included therein and made compoundable, it too will help in making a dent in the mounting areas of the saving time of the courts. The trial should not be delayed so much as to cause grievance to the litigants as well as the persons who have been roped in for the litigation. The right to speedy trial has been implicitly read in Article 21. The Supreme Court in Hussain Ara Khatun's case held that any accused who has been denied this right, the state is under a constitutional mandate to take all necessary measures for securing the right to the accused. Thus, the letter of law recognizes the right of an accused to speedy trial, but the problem is how to make it a reality. The test of a good law is that it must be able to achieve its goals, that is, the dispensation of justice to the individual and society. The Supreme Court ruled that to put a man in prison and forget his personhood thereafter, to deprive a man of his personal liberty for an arbitrary period without monitoring by law, to keep a man in continued custody unmissed of just, fair and reasonable procedures would shake in the rule of law, and is totally against the mandates of Part 3 of the Constitution. The trial should be disposed of expeditiously, for which the government has taken adequate steps. In order to reduce the pending litigation between various governments and the helpless citizens in the high courts, tribunals, other foray and subordinate courts, there is an urgent need to set up an internal mechanism at the central, as the state and district levels in the government offices by the respective heads for resolving the disputes and for making bona fide attempts to resolve the same with an open mind. I have no doubt that such efforts would never go in vain, and disputes in vast majority of cases are bound to be resolved, whereby not only public time, energy and money would be substantially saved, but people's faith in all the three limbs of state would be resuscitated, which is the need of the day. I'm certain that with the measures already taken, which are already showing positive results, what I feel is that there should be aptitudinal change in the bar and the bench. Judges should develop a knack of deciding cases in the shortest possible time, and the members of the bar should be able to place their points without loss of public time. After all, the bar and bench both owe a duty to the litigant to dispose of the matter as soon as possible.
Thank you, Nishant. Nishant spoke about appointment of judges, facilities, and how this pending